Will be available to visit all the details with assessors to enable them to respond at section 69, that is if they have any objection, especially the defense. Otherwise, I've listened to them before they take oath at the commencement of the trial. I will now Just a minute.
Secrecy.
Yes, I'm coming back. Want to finish the advocates, then I conclude with you. I need to know if there is any other advocate who wants to say this again.
They are not advocating on our behalf.
Let me hear from the kind.
They are accused in this matter.
I'll come back to you. Let me know if I was saying anything like close that chapter.
They cannot speak on my.
Let me hear from them that they are not speaking.
I'm the one who gives them instruction.
It's okay. Let me hear that they are not saying this. I close them and come forward.
My Lord, I use this place.
Okay.
My senior colleagues are in the space. Require that I include
So what journey look at? Abalungi abatuwuliriza era abatulaba olunaku olwaleero tukyaddeko ewa Sheikh Asiraf Dembe.
Ssebo nsanyusa okubalaba. Amannya agange Seeka Asiraf Dembe akola ku bizibu by'enjawulo. Omuntu singa aba alina ebirwadde tumusomereddwa, tumuwa amazzi ga lukuya nga bw'obadde ogalaba, tugenda abantu ku kyoto ne twokya emizimu emibi egibabaamu n'okulomba edduwa. Abantu singa abeera ng'ali wano atuuse sobola okumulombera edduwa, ne waba atatuuse nga mpadde amannya ge naye ng'ali wala. Neetaaze enamba yange yeeno eri 0707763711. Nammwe bannyinaffe abali ebweru oyagala okuba nti oyagala okulombera ku dduwa ng'olina ebizibu, viza zibuze, amaka gakolongotana, sente zikola zimpita mu ngalo, ojja kumpeereza ekifaananyi kyo n'amannya go, ebyo byokka bijja kummala. Nja kukulombera edduwa, ojja kutereera. Olunaku olusembayo mu mwezi mba n'edduwa ey'awamu ffenna n'abalwadde bange abakadde n'abapya. Salaamu alaikum warahmatullahi wabarakatuh.
I'm just seeking clarification from the court, which clarification I could not receive from my lawyers, as to where we are in this process. As the preliminary, yes, as the preliminary hearing ended, has it begun? Is it still to begin? It's not clear to me, because the issues to be resolved in the preliminary hearing, to my understanding, need to be resolved before we talk about assessors. Assessors come after the preliminary hearing. And as a great court this morning, there have been 7 issues which were presented to court, which are critical to the preliminary hearing. which is us accessing the documentation that has been presented to be relied on by the prosecution in our trial. We haven't received it.
Accessing what?
The documentation
Which one?
which the prosecution needs to is to rely on in this trial.
Which is
The disclosures, we haven't seen them up to now. You ordered prisons should facilitate that. At least the access of lawyers. The facilities we need, which have been listed. This has not happened yet. The other preliminary matters of concern that were presented to court this evening have not been disposed of. The other issues considered the preliminary hearing, which were presented to court this morning, have not been disposed of.
which one is that?
Including the applications.
The other one for bail application?
There are two applications that were presented this morning. We have not seen anything. I don't know how we can start trial before we know even whether we have other issues to raise in the preliminary hearing. So what I'm seeing to know is where we are.
Yes, I have looked at that. Where is it? What is it?
My Lord, Representative April.
This is
April. If I may refer to the response of the treason you just read to us right now, reported. If I'm to refer you to the response from the treason, is dated 8, which is today. And that is the letter which is granting us access, our lawyers access to see us. And that has not yet taken place. I'm wondering, we are now proceeding to choose the assessor, yet, to me, I believe pre-trial has not yet taken place. So I would, in the same vein, request this court to guide me to understand. Thank
do not put the attention of this honorable judge. I came to court. I was not at the same time looking even at Dickens. So if that application is there, wouldn't have still stopped this court to continue with preliminary hearings. It would be, in my view, speculation to stop this hearing on application that I have not seen. Finally, the issue of assessors. The registrar forwarded to this honorable court 5 assessors. This court has gone ahead to choose the assessors. I have given opportunity to the defense to respond, which counsel for A1 and A2 have not responded. But counsel for A3 requested the copies of the details. But I directed that the details of all the chosen 3 assessors be availed to the defense. I'm directing the registrar to avail all the details of the assessors. Now, if the defense, in any case, the prosecution said that they have no objection to the assessors, so I'm giving a chance to the defense to look at the details of those three assessors, and before they take post this case at the hearing of the case, they will first address what they have to challenge. So for the assessor, especially the three chosen, but I'm electing even others to come back on 11th this month. And the prosecution has earlier warned. I'm now directing that by the nature of this case, I'm ordering that we first bring one witness. Commence the trial, bring one witness on 11th of June at 11. And then from there, we start. So,
That's the application.
yes. It is detailed. If you speak,
So it has been clarified that what has been going on has been preliminary hearing.
it has been crossed.
So I think really, I think
Preliminary hearing has been closed.
if it has, I think Mr. Museveni should stop being shy and reenact trial detention without trial. So that we know, instead of harassing courts to do what you are doing, which is really awful.
mu nsi buli omu alina ekirooto kuba kuwaguza kulafuubana n'okulemerako okutuuka ku buwanguzi ddala wamma ggwe luba lunaku mulindwa okyasobeddwa eka ne mu kibira nga weebuuza omuntu omutuufu anaakutuusa ku makula g'ebirooto byo oba okooye kuferebwa kankwanjulire aba Brand Pro Property Services Limited abeegulidde erinnya mu kutuukiriza ebirooto by'abantu ebyekuusa ku ttaka bagula wamu n'okutunda ettaka n'amayumba ku buli luguudo lwa Uganda wamu n'okwetooloola ensi yonna mu mawanga agatali gamu nga USA, India wamu ne Bungereza. Tulina estates eziwedde okuzimbibwa. Gano makula bukula weegulire ennyumba ey'ekirooto kyo olwaleero ku bbeeyi esoboka. Naawe anoonyeeza okupangisa tuzirina ng'ate tusobola n'okukulaakulanya ettaka, amayumba oba estates zo ne zeegombesa buli muntu. Oyagala saveya oba olina ekizibu kyonna nga kyekuusa ku ttaka bitukwase ng'osirike. Tusangibwa ku MT House ku mwaliiro ogusooka Room 5 ewazana ku Entebbe Road okuliraana ekizimbe kya Muguluma Empire. Osobola okutukubira oba okutuweereza obubaka ku WhatsApp namba zaffe Note 773 216 588 Note oba Note 703 824 Note 79 ne ku website www.brandpro.co.ug. ate mwe bankuba kyeyo ebyammwe byateredde anti osobola okugula poloti oba okufuna ennyumba n'okomawo nga buli kimu kiri malidaadi saana. Sebatuka abafera olwaleero ng'okolagana ne Brand Pro Property Services Limited tutuukiriza birooto.
In response to the application by Senior Counsel Lukwago and Kalipara, prosecution, my lord, submits that there is no question of law that has arisen out of the ruling of this court, to which having the matter adjourned to 8th of June 2026 for 1. Preliminary hearing. And 2, selecting or appointment of assessors and taking their oath. B, having the matter fixed on the 11th of June 2026 to have prosecution produce their first witness and therefore commence the trial substantive. My Lord, our understanding of the application, Counsel Kalipala stated that this court has interpreted Article 28(3)(c) of the Constitution to mean that adequate time for trial means 7 days. And to them, that this kind of interpretation has a ramification on the subordinate courts. Before my Lord, we submit on whether or not that is true. We wish to just give a small background in a short time. Whereas it is true that prosecution did the last full disclosure today, 1st of June 2026. This was partial and it constitutes close to 10% or 5% of the total disclosure prosecution had done. My Lord, just remind this court. Prosecution did the first disclosure on the 21st of January 2026.
Is it?
On 21st January 2026. We did a second disclosure on the 4th of March 2026.
Is it?
On the 4th of March 2026. In between there is when we made the application. We made application number 101 of 2026 for protection of witnesses. And my Lord, that was after doing a third disclosure of redacted statements. That was on the 11th We did redacted disclosure on the 11th of March 2026. That redacted disclosure, my lord, was only in respect to the names of the witnesses, their residential areas, and contact information. Otherwise, the rest of the information was intact. In effect, my lord, the disclosure of today, the full disclosure of today, was just in respect to names of the witnesses, their particulars, basically, and the contact information. My lord, the rest of the information has been at the disposal of defense. For now, close to 3 months. Yes, I'm just to play back on my lord. Just to come to the 7 days, my lord.
On the constitutional question which we asked.
My lord is where I'm bringing it, and I'm going to the point now. My lord, the context of 7 days is coming in to reflect as if prosecution has made all the disclosures now, and that the defense has all the 7 days within which to use that disclosure and prepare the trial. That is why my lord, we gave the backup. Which is not the case, my lord. My lord, it is not 7 days per se. The defense has had this information for some time, save for the particulars of 5 witnesses whose disclosure was done today. So, my lord, even if court was to say, even if court said 7 days, there is no question of law. There is no question of law that has arisen. And my lord, that takes me to the history I've been giving you. That when Senior Counsel Panga read to court the pages of the disclosures prosecution did to defense, was painting a picture like all those pages, audio visual, were disclosed today, which is not true. My lord, it is worth noting, my lord, and commenting on the issue raised by Senior Counsel that this court is granting 7 days as per the application of prosecution for police protection. You don't have to go into that because it doesn't form part of these proceedings. Because that application was withdrawn no question of law. Because even Article 28 simply talks about reasonable time. Talks about reasonable time within which adequate time within which the defense has prepared their defense. Our submission is that there has been adequate time right from the first disclosure, which was made on the 21st of January 2026. My Lord, we pray that this matter, this application, my Lord, be dismissed. Mr. Commissioner.
My Lord, in this month of June, we have two public holidays. One is on the 3rd, the other one is on the 9th. One is on the 3rd, Mother's Day, the other one is on the 9th, Heroes Day. So if we remove those 2 days, and we just count from today to the 11th, we are at 7 days.
If you remove those 2 days, though,
Count from today to the 11th of June and remove those 2 days. We only have 7. If we take out Saturday and Sunday, then we should have smaller number. So, my Lord, I do not expect that we will be arguing about the number of days or how they arise, but that's how they arise. My Lord, in preparing a defense, it is always necessary to review evidence holistically. So you don't review evidence bit by bit. You can only conduct a comprehensive review when you have it all. The disclosure of names and particulars has an effect on the review of evidence. So whereas it is being minimized as only that which was supplied today, in fact it affects the ability to holistically review evidence or discuss it with the accused person. So my Lord, we submit that the adequate time must be computed from the time, the date, when full disclosure has been confirmed. As the record will show, that is today. The submission that there is no question to refer, or that there is no interpretation that has been given by this court, is quite surprising. Because, my Lord, there was a prayer for a certain number of days as constituting adequate time in the eyes of the accused. There was then a decision, my Lord, in which prayer was for 30 days, the order was for 7 days. So my Lord, we contend that in that decision the court has given meaning, has ascribed the formula, has pronounced the application of the words adequate time as used in that Article 28(3)(c), and has also pronounced on facilities. In this case, being simply the ability to access the accused persons over the weekends and public holidays. So, my Lord, a substantial question of law does arise. That question has an effect on this case, has an effect other cases in the High Court. Because my Lord, decisions at this level are many times cited as persuasive, but also has a binding effect on other courts. So it is our humble submission that the court finds that the question has been disclosed and we proceed to frame it. My Lord, the court has repeatedly cited Article 28(1), mainly on the speedy trial that has been consistent.
So, Karibara, go ahead and frame your question, bro, because it is you who wants it. Frame it, the one you want this court to not problem.
My Lord, if I may finish,
because you have your...
if I may finish on the other point. I'm grateful that the court has agreed that I should frame the question.
Yes, because I want to...
My Lord, there has been repeated reference to a speedy trial. We submit that it doesn't mean rushed trial. Because, my Lord, justice which is rushed frequently is justice which is crushed.
But on the other hand, you have submitted that this case has over delayed and the Adduse-Dr. So which rush are you talking about?
That's what, my Lord, I'm saying that the court has repeatedly focused on the speed. We are now focusing on the fairness.
Yes.
Because adequate time, my Lord, adequate time and facility goes to the fairness.
That's when you say.
So I'm not finished on that submission. I will now.
Well, I wanted you to take forth and frame the question you see.
If my Lord, I could get just a minute to consult with
Yes, so that way.
whether you play ordinary meaning, whether you play ordinary meaning, after full disclosure is concluded, the period of 7 days for fact of hearing.
Whether the act of the trial judge, act with small a, act with a small, whether the act of the trial judge ordering commencement of the hearing of session case number 335 of 2025 before concluding the preliminary hearing is inconsistent with Article 28 of the Constitution. Article 28. Article 20 and 44. They move together. Non-derogable.
Specific directions or constitutional reference. The date of 8th June for preliminary hearing and the commencement of the trial on 11th June in the ruling today before 5 p.m. and I will deliver these rulings through e-keys and emails and the back. Today,
when are we coming back? My lord, how about the bail application?
And I didn't decide about
No, but we will file the application, the bail application. Come on, come
Uganda Eyenkya.